program organized by Delhi State Legal Services Authority for its panel lawyers on the topic Role of Legal Services Advocates in Amicable Settlement of Disputes with special reference to mediation techniques. I extend a heartfelt welcome to each one of you for sparing your valuable time to attend this session. It is indeed a pleasure to welcome amidst us Honorable Mr. Justice Sudhir Kumar Jain, Judge, High Court of Delhi, who shall be talking about the rise to eminence of mediation in the contemporary dispute resolution landscape and its unique value propositions and the consequential transformative potential of mediation. I am also deeply honored to welcome amidst us Shri Vinay Gupta, Learned Principal District and Sessions Judge. He shall also be sharing his invaluable insights about the use of mediation as a dispute resolution technique. We also have amidst us Shri Mukesh Kumar Gupta, Learned Member Secretary, Delhi State Legal Services Authority, who conceptualized today's capacity building program so as to equip the empaneled lawyers of DSLSA to use the techniques of mediation to amicably, effectively, and speedily settle the disputes, thereby creating a win-win situation for the parties litigating. We also have with us Shri Sushant Changotra, Learned Special Secretary, DSLSA, and Shri Lalit Kumar, Learned Secretary, Central 2, who always work their fingers to the bone to make each program of DSLSA a resounding success. At the start of this session, which shall shed new light on the transformative potential of mediation techniques, it would be befitting to kindle the lamp of knowledge and wisdom. For the ceremonial lighting of the lamp, I invite Honorable Mr. Justice Sudhir Kumar Jain and other distinguished dignitaries on the dais to kindly light the lamp. I now take this opportunity to present a memento to Shri Vinay Gupta sir. With this, I would like to call upon Shri Mukesh Kumar Gupta, Learned Member Secretary, to kindly deliver the welcome address.
Honorable Mr. Justice Sudhir Kumar Jain, I should say Honorable Dr. Justice Sudhir Kumar Jain, Judge, High Court of Delhi, Honorable Shri Vinay Kumar Gupta, Principal District and Sessions Judge, and Special Judge PC Act CBI, my secretaries, Special Secretary Shri Shashant Chandra, Harshita and Lalit, legal services advocates of DSLSA, ladies and gentlemen, a very good afternoon to all of you. So, how are you people today? Sleepy? No? Alright. A very warm welcome to all of you in this capacity building program for legal services advocates on the topic role of legal aid counsels in amicable settlement of disputes with special reference to mediation techniques. As the head of an institution responsible for providing legal services to the public, I am delighted and thankful to all of you to see such a remarkable turnout of dedicated legal services advocates who share our vision of Seva, Samadhan and Samadhi. Before I start my address, there's one poem which I like the most as a trained mediator. Whenever I have been sitting as a mediator in any dispute, I always used to, remember this beautiful poem written by one of our colleagues, Shri Sanjeev Jain, who was a former member secretary of DSLSA. So, the name of the poem is Hal Niklenge. Starts, आज नहीं तो कल निकलेंगे, बातचीत से हल निकलेंगे. हारी बाजी रुके काफिले चल निकलेंगे, आज नहीं तो कल निकलेंगे, बातचीत से हल निकलेंगे. हार जीत ये बेमानी है, खूनी खंजर कल निकलेंगे, आस की बाती हवा प्यार की, बुझे दिए भी जल निकलेंगे, आज नहीं तो कल निकलेंगे, बातचीत से हल निकलेंगे. And the last stanza is, तुम जीतो. Please remember each word. Honorable Mr. Justice, Honorable Dr. Justice Sudhir Kumar Jain sir, who is a doyen on mediation techniques, will reflect upon each and everything. Please remember each and every word. तुम जीतो पर मैं ना हारूं. तुम जीतो पर मैं ना हारूं. वैर के मौसम ढल निकलेंगे, पौध लगाएं सरहद पर, बच्चों की खातिर फल निकलेंगे, आज नहीं तो कल निकलेंगे, बातचीत से हल निकलेंगे. So you see, how we settle a dispute amicably. If you see the world today, it's plagued by conflicts and divisions. Fostering peaceful resolution to legal disputes is a vital work for overall well-being and harmony of communities. If we have a tranquil society, we have a nation which will develop in its own. Amicable settlement promotes reconciliation, understanding, and cooperation amongst parties involved, mitigating the adversarial nature of traditional litigation. By encouraging dialogue, empathy, and compromise, amicable settlements allow individuals to preserve relationships, which is crucial in family, business, and community settings. Further, amicable settlements save lives, time, costs, and resources, enabling parties to move forward with their endeavors. Additionally, when legal disputes are resolved amicably, the burden of the main judicial system is elevated, allowing the courts to focus on more complex and maybe more serious and contentious issues. Ultimately, the promotion of amicable settlement contributes to a peaceful and cohesive society with fairness. Amicable settlement, or what is now transformed into mediation, is not unknown to Indian culture. Let me cite one instance that comes to my mind from one religious text. Lord Krishna, before this Mahabharata war, Lord Krishna was there to act as a mediator. He came to court of King Dhritarashtra. So when that day came, he arrives in the Kauravas' court as a messenger of Pandavas and makes a speech to the king. Dhritarashtra, for peace, let's settle down. He gives a statement from Pandavas which essentially tells the king that they did their dharma while living in exile, and it's now the king's time to follow the path of dharma and secure peace. Lord Krishna gives the entire court a statement from Pandavas which asks them to do their duty and recommend path of righteousness to attain peace. If the speech is carefully seen, Lord Krishna applied various techniques to make case for peace and avoiding the war. Lord Krishna first tried to establish brotherly feelings between Pandavas and Kauravas. One of the mediation technique. Second, when conciliation failed, Lord Krishna used the art of producing dissensions. This is also one of the technique. In doing so, Krishna mentioned Pandavas' prowess, that's what they are. And thirdly, when Duryodhana disregarded this, Krishna tried to produce dissensions between all the members of Duryodhana's court. At this stage, because Krishna criticized the kings, used fear tactics, may not be actually applicable, and admonished Duryodhana for fraudulent game of dice, he regained a recourse to conciliation. Now, what do we understand from this? Mediation is a structured process, unlike any other negotiation which happens between the parties. A trained mediator applies techniques of mediation, a structured process. So, we learn 4 things from this Mahabharata's incident regarding mediators. First, for all of you, a mediator's ideal qualities. Second, guiding principles which a mediator should follow. Thirdly, a mediator's mental plan. And fourthly, a mediator's method of communication. This indicates that we should follow these principles in order to attain better peace in the society, resolve disputes. Now, one of the important aspects is that sometimes we have difficult party counsel from the other side. So you'll have to see that, you have to show them that peace is the best option available. Now, one of the important things is you have to see there's a flexibility amongst the parties in the endeavor, so that the mediator's way of securing peace is secure. So, this was the incident which I remember. Now, what is the role of DSLSA advocates or DSLSA counsels, which we call legal services advocates? We as an institution are constantly working to provide free and competent legal aid besides spreading awareness and legal literacy. One of the mandate of Legal Services Act 1987 is that we should promote the ADR mechanism. Mediation is one of the ADR mechanism besides others which are local adalats and other adalats. It's a resounding mechanism. And with time, in fact, if you ask me, 2006, my Lord Mr. Justice Sudhir Kumar Jain sir was posted in Rohini. I was just 6 years old in the service. I have seen, I happened to attend one of his class just like a friend. I just went there and I was sitting. I remember in 2006, mediation was looking like, what is this? We do this day in and day out in courts. But today, if you see the kind of success, the success rate as per the data which is available shows mediation is successful in 74% in resolving disputes as an indispensable tool for achieving swift and amicable settlement of individual and business disputes. As legal services advocates, your role would be to convince the litigant to prefer an amicable settlement of legal dispute over the traditional method of litigation. You will be the forefront of providing legal guidance, support and representation to those who may financially, who may require the same and who are actually on the fringes of society. So by adopting these means, a number of disputes can be amicably resolved through ADR matters, ADR techniques, which is cost-effective, time-efficient, and preserve relationship, bringing peace in the society. I would call upon each one of you. See, this is a capacity building program. Capacity building is something with a person like Dr. Sudhir Kumar Jain and Vinay Kumar Gupta sir. As a resource person, you people are fortunate. These people are those people who have created this mediation movement, if I have to say, in the entire country. They have not only trained people, but they have trained the trainers also. And now they are internationally recognized. So these, I'm very fortunate, DSLSA is very fortunate, and I should say, I'm very fortunate that I have the occasion of calling one of the best resources for people. So I would say each one of you, ask questions, clear doubts, do your best. Happy learning. Thank you very much.
Thank you so much, sir, for this welcome address. It just sets the tone right for today's session. So now, before we commence with the technical session, I would like to briefly introduce Honorable Mr. Justice Sudhir Kumar Jain, Judge High Court of Delhi, and Shri Vinay Gupta, sir, Learned Principal District and Sessions Judge. Honorable Mr. Justice Sudhir Kumar Jain completed his legal studies from Faculty of Law, Delhi University. He is one of those rare personalities who get an opportunity to teach at their own alma mater. So sir briefly taught at Faculty of Law before joining Delhi Judicial Services. Before joining the Delhi Judicial Services, sir had also practiced at the Delhi District Courts and High Court of Delhi. Sir has presided over diverse jurisdictions. Sir also has the unique distinction of having been the Joint Director, Additional Director and Director of Delhi Judicial Academy at different points of time. Sir has also been a member of the Academic Council of the National Judicial Academy at Bhopal. Sir is an accredited mediator of the International Mediation Institute at Holland and is well known across the country for his contribution in this field. As head of the Mediation Center, 30 Hazari Courts and Rohini Courts, he had shown exceptional dedication to all mediation cases, ensuring that all parties are satisfied with the result of mediation. Sir has an academic bent of mind and has produced a steady stream of scholarly writings. Sir has an endearing personality, and his scholarly attainments and warm humanity make him a great judge. Sir was elevated as a permanent judge of the High Court of Delhi on 28 February 2022. Shri Vinay Kumar Gupta, Sir also completed his legal studies from Faculty of Law, Delhi University, before joining Delhi Judicial Services in the year 1992. He is also the recipient of the Sukhdevi Girdhari Lal Grover Award in the year 1989 for securing the highest marks in constitutional law. Sir has also presided over courts of diverse nature and has been the in charge of Mediation Center, Patiala House Courts. Sir has authored several books for Judicial Services Examination and books on civil law. When we have such legal giants amidst us, it doesn't behove of me to stand between you and these legal stalwarts. So without any further ado, I hand over the stage to sirs, the respected resource persons for today's session.
Before Sir starts, one of the quality which nobody will be knowing, Sir is, he was my chemistry teacher in class 11 and he has taught me well.
Good afternoon to all of you. First, let me extend my heartiest gratitude and thanks to Delhi State Legal Services Authority and its member secretary Mukesh Kumar Gupta and other Harshita, Sushant and Lalit for giving me this opportunity to be present amongst all of you. Mukesh reminded me my law faculty days. I joined law faculty after completing my BSc in Geology Honours, and chemistry was particularly the organic chemistry was one of the favorite subjects. So as and when I get an opportunity to catch hold of unwanted student, so I used to teach the organic chemistry. But those were the good olden days during college time since long.
I got 98 marks after Sir has taught me.
Right, and also let me extend my thanks to Mukesh and Harshita for giving such a wonderful introduction about me. And honestly speaking, even I myself was not knowing many of such qualities about me also. But when Mukesh and Harshita introduced me, so fortunately I also come to know about these qualities also. Mukesh and Harshita again and again called, we are having the two best resource persons. But in every program, training program, I never called any training program, say interactive program, because in such program we are dealing with the adult learners where there is no distinction between the resource person and the learner. It's a purely collaborative exercise. So in this room, me and Gupta ji are not the two resource person. All of you are sitting in front of me are equally good resource person. In this talk, you need to contribute, you need to share your own experience also. As and when I conducted training in the past, my first message happened to be to the participant, that this is not a training program. Nobody can train you, nobody can teach you. All of you are well mature person, having vast experience at the back of your head. All of you have dealt large number of cases in litigation as well as mediation. Nobody can dare to teach you or give lecture to all of you or any one of you. Coming to this place is like coming back to home for me also. In this room, in this conference hall, I also welcome many resource persons. I remained there posted for around 13 months to conduct it. I still remember just immediately after my elevation, and that program I scheduled before my elevation, that is interaction on mediation with the advocates and representative of the labor union, those who are looking after the labor management dispute in this room also. You know, all of you are having a different role to play in the society. Your role is entirely different from an ordinary advocate. Advocate, a legal professional who is after charging professional fees, he used to fight or contest the case in the court of law, but for another purpose. But all of you have joined your hands with the Legal Services Authority. The basic idea why all of you are here is the access to justice. Your commitment, your dedication to the cause of justice, to the access of justice to the needy person. So you have submitted to this this noble cause. As Mukesh has mentioned, Member Secretary Sahab has mentioned about the conflict, right? Every conflict, you know, conflict are the part of our life. They are inevitable, ever present. We cannot presume or assume any day in our life which is without any conflict. If I want to come to this place, the color of shirt which I need to wear, if you want to go to a restaurant, the kind of food you want to have, if there is one vehicle is available in home and two person they are about to leave the home, who will use the vehicle, you know, every day we are facing the conflict. But in our life we cannot avoid the conflict. We cannot run away from the conflict. No conflict can be stated to be good, no conflict can be stated to be bad. But once the conflict is there, we need to address the conflict. You know, happiness in your life is not the absence of conflict. What is happiness? Happiness is our ability, how we handle how we address the conflict, how we manage the conflict. Right? If we can address the conflict in a right perspective, we can find out many viable, practical solutions. If I ask a very simple question from all of you, if father and son, they are fighting with each other. The son is saying, my father, my school or college is situated very far away from my place of residence. Every day I am getting late to reach at my place of education. Please purchase a motorbike for me or a car for me. The father is having some financial issues, and what he also considered, that nowadays it is not safe to drive motorbike on the road. So he is not willing, little bit hesitant to purchase the motorbike for his son. So this lead to some difference between father and son. If I ask very simple question from all of you, who is right? Whether father is right or son is right? No. A suit cannot be decreed in both in favor of plaintiff and defendant. All of you are advocate, either suit can be decreed or it can be dismissed.
We try for the compromise degree.
No, I am not asking for the compromise. Don't start your journey so quickly. My question is very simple to all of you. It's not a question, very simple query. Who is right? Father is right or son is right? See, what your assessment like a prudent man or an ordinary man, common man say? Who is right? Father is right. Son is not right. He is studying suffering badly. He has to miss many classes. His demand is very genuine कि Papa purchase either bike or car for me so that I can reach at my college well within time so that my study should not be allowed to be suffer. So son is not right.
You can't force it.
He is not forcing. He is not forcing.
He can
Very simple question.
in other way also. He can rise early in the morning.
I am not asking the solution. You know, why no basic problem is we immediately start to rush to the solution. We jump to the conclusion. I started my journey only. I've asked very simple question, asking very simple question. Bhai, बाप ठीक है या बेटा ठीक है? Some of you said father is right and some of you may say son is right. Son is right. So why, on the similar circumstances, similar situation, why this type of two kind of solution? Some of you are saying father is right, some of you are saying son is right. Why?
Perspective.
Your notion you carry. Yes? Who said perception?
Yes, the perception.
A perception. So everybody is having different perception. And when we talk about the conflict, you must appreciate one thing, that our perception is the genesis of the conflict. Why we are having a conflict in the society? Because of different perception. Right. So this is a conflict before you. Suppose, if this conflict is referred to you as a mediator or as an adjudicator, sitting on the dais, you are holding a court, what you will do as an adjudicator?
Make both the parties come on the same
I
page.
would
If
first
we
like
have
to
to
hear
resolve
both the
it.
parties, so they will get out their things.
No, I am asking what you will do as an adjudicator, not as mediator or conciliator or a person who can affect the compromise.
See the law, apply the law, and we will-
Entitlement. First, let's go one by one. First, you will ask the completion of pleadings. Then you will frame issues. Then you will ask the father and son to submit evidence, lead evidence, or submit document, if any. If then after completion of pleading, filing of documents, completion of evidence, then what you will do? You will pass a reasoned judgment, not simple order or judgment, a reasoned judgment. You will say either father is right, you will give the reason, if the son is right, right? So ultimately you will be finding the fault in one man, either in father or in son. So do you think this is the complete justice? This is a practical and viable justice, acceptable justice? Then appeal, second appeal, further litigation also. Suppose if this dispute between father and son is referred to you as mediator, what you will do?
Switch on the mic.
Yeah.
Switch on the mic.
You will go for amicable settlement. But how will you start your journey? How will you proceed with your journey and how to conclude your journey?
make both the father and son understand each other's perspective first. So
Yes,
that
father and son perspective, to understand the perspective of each other. How will they understand the perspective of each other? You know, simple. When you are submitting pleadings to the court, what you are doing actually? क्या करते हैं जब आप pleadings को submit करते हैं?
stating
You are giving your information about your case to the court.
Yes.
Plaint is the perspective of plaintiff. Written statement is the perspective of defendant. So when this dispute would be assigned to you, first what you will do? You will try to gather information. अगर कोई client आपके पास आता है and he gives you the information about the case, you hardly call any stenographer immediately and dictate the petition or plaint. What you do first, you organize the information. Articulate your information, what you have gathered from your client. So first you will gather the information, then you will organize the information, and then exchange the information between the parties. That you will do. Right? Now my next question, just give the answer. No explanation. पीछे क्या है? No reasoning. How would you like to settle this dispute? All of you have shouted, we will try to settle, we will try to settle. Tell me the ultimate solution.
Negotiation.
Negotiation is the way to settlement. I'm not asking how you will cover your way. I'm taking you on the destination.
And maybe get a bike on rent.
You may get a bike on rent. Very good.
I would tell father
father to drop the child at his
Father can drop the child. Wonderful.
or explore hostel accommodation.
Explore
PG,
hostel accommodation nearby college.
Use public transport
Use public transport.
or buy a second-hand car first.
Buy second-hand car from this side. No solution. All adjudicator.
Buy a second-hand motorcycle.
Second-hand motorcycle कितनी बार परचेज करोगे सर? हो गई.
If father cannot afford car.
नहीं second-hand motorbike परचेज हो गई. अगला कुछ और बताओ. Just open your mind. Why I'm asking you?
Online classes.
Online classes. Very good. Now
Change the school first.
change the school also. Whatever may be the solution. Now, for a one problem, first you gather the information, you organize the information, you try to understand the underlying interest of the parties. The underlying interest of the son is to reach school on time so that his study should not be allowed to suffer. What is the underlying interest or what are the underlying interests of the father? Safety of the son and financial issue. This, अब आपने by gathering information you could manage to two things you could manage to do. Two things. First, you could understand the factual background of the dispute or conflict between the parties, and as well as their underlying interest. What you will do next? You created many options. Online classes, वहाँ shift कर लीजिए, second hand ले लीजिए, father can drop, public transport, number of options you have generated. So next would be, when you are addressing the conflict, next step is the generation of options. And then what you will do, after proper evaluation, what you will do?
Communication.
You will convert one option into settlement which is acceptable to both the parties. So see how the dispute can be addressed in court litigation or as in mediation or in compromise or as a conciliation. Could you manage to notice the difference? See, in judicial adjudication, there is no place for option. कि वकील साहब A judgment कर दूं या B कर दूं या C कर दूं. No, only one judgment is possible. What is emerging from the facts and law and document. But when you are addressing the conflict, in a way, apart from adjudication, many solutions can be generated and one solution can be converted into the potential settlement. So as and when there is a conflict, I said, no conflict is good, no conflict is bad, but what we need to address the conflict in a proper or perspective, in a right way. And one thing is more. What I always consider that court litigation, court adjudication is a kind of fluid justice. There is no certainty. If the judgment is given by first court of first instance, then first appeal, second appeal, writ petition, SLP. And the second, by way of conciliation and mediation, what you could find out a solution, it is a kind of sustainable justice. No party would like to go for further litigation because the suggestion or solution which you have given, it is satisfying the underlying interest of both the parties. So there is a difference to what we can say. There are multiple ways by which we can address a conflict, maybe adjudication, maybe resolution. Adjudication, the court system, but resolution, like Section 89. Before Section 89 was introduced, when the Section 89 was introduced, when the Section 89 was amended in Code of Civil Procedure in year 2002, it was made effective from 1st of July 2002. आपने amended Section 89 पढ़ा है जो है? पढ़ा है. किसी ने unamended Section 89 पढ़ा है? कभी देखा हो सीपीसी में 2002 से पहले क्या था उसमें? Very good. All of you are honest. Because before 2002 there was no Section 89 in the CPC. It was repealed when Arbitration Act 1940 was enacted. There was no Section 89. And very delighted to see, very pleased to see all of you are honest in your approach. Right? Then section 89, when it was introduced, the first time the word mediation was introduced in legal system. As per section 89, if there is element of settlement, the case can be referred to mediation, conciliation, arbitration, judicial settlement, including lok adalat. When section 89 was introduced, reincorporated, its wires were changed before the Supreme Court in very famous case, Salam Advocate Bar Association versus Union of India. There are two judgments delivered in 2002 and 2005. First was delivered by Honorable Mr. Justice B.N. Kirpal. Second was delivered by Honorable Mr. Justice Y.K. Sabharwal. The constitutional validity of the section 89 was upheld. But this case does not end by merely upholding the constitutional validity of section 89. The court said it's a new provision, section 89. The court also referred the use of ADR mechanism. This is all, they are the all ADR mechanism. Conciliation, mediation, lok adalat, arbitration. The Supreme Court has said 90% of the cases are addressed by the ADR mechanism in different countries. Then Supreme Court has also said it is a new provision, it need to be tried. Because all the cases which are filed in the court, they don't deserve the complete trial. Many cases can be resolved, can be settled before undergoing the rigor of the trial. अगर आपने कोर्ट हॉस्पिटल में देखा होगा ना, एक ओपीडी डिपार्टमेंट होता है, आउट पेशेंट डिपार्टमेंट. जरूरी नहीं कि जो हॉस्पिटल गया उसको एडमिट ही करना है. Many patients, they can be treated in OPD also. So like this, the many cases can be settled, can be addressed, can be resolved in OPD, like by use of section 89. Then came to second. Now, very important, now coming to issue with this little bit background, what is mediation? What is mediation? You must have heard mediation. Like Mukeshji also said, Madam also said, learning. It's a capacity building program. Capacity building by learning in getting. If I ask from all of you, what is learning? How will you define learning? Suppose you want to argue one application under Order 39, Rule 1 and 2, CPC. You must have argued number of such application in your career, professional career. But what you will do? Suppose next day your case is fixed before the court and you need to argue one case. Maybe 39, 1 and 2, maybe murder case, maybe criminal case. What you will do?
Read the file first and then
You will read the file. Very good.
read the law,
Read the law. You will do a lot of reading.
Find the judgment, sir.
You will find the judgment, read the judgment, और सब जज साहब के सिर पे दे मारोगे. First reading say, I want to refer this judgment, I want to refer. Yesterday I was telling first of all senior counsel, कि sir you have submitted large number of judgment. Who is going to read? At least I will not. I am very. But by mere reading is sufficient.
First of all, sir, we will collect information by reading the facts, by
You
connecting
will
the
collect the
parties.
information. By this, all right.
But after that, we talk to our client also.
You have already talked to your client. You have, suppose you have gone through large number of judgment, you prepared file very well, right? Without any confusion, without any question. But this is sufficient. Whether it will produce desired result in your favor. You need to present before the court.
What is the
You need, no, you need to deliver before the court. You need to deliver before the court. Suppose I fumbled before the court. What I could prepare overnight, I'm not able to reproduce before the court. Whether it will serve my purpose? No. So learning, because by this mediation you will be learning a new technique. So two aspects. So first, internal process of reflection. What you have read by gathering knowledge, information. And second is external process of application. What you could do actually is a skill based. Gathering of information is knowledge based. Knowledge करने से कुछ नहीं होगा मगर जब तक आप कोर्ट में आर्ग्यू नहीं करेंगे. तो इससे when you are reading mediation technique, you need to two things. First, what is mediation and how the mediation can be applied in resolution of dispute. So first we will try to understand what is mediation, what are the important components and benefits of mediation, why it is required. Yes, what is mediation? Any one of you? मैंने कहा था कि सब resource person है, नंबर मिलेंगे सबको.
It's a voluntary process.
Amicable settlement of dispute, like parties are reaching at an acceptable,
mutually acceptable solution. It's a voluntary process. इसे Gupta ji also said structure process also amicable solution. So you can define mediation is a structure process. It involves a third person. Who is the third person? Mediator. A neutral person. What the mediator does?
Make the parties
He takes the parties towards amicable settlement. But how he will take? First, he must have some quality. What he does, he facilitates. He does not convey the settlement between the parties. He is not the master of the settlement. Master of the settlement are the parties themselves. But he facilitates the process. He facilitates the process how to reach a settlement. अगर मुझे क्लॉट प्लेस से अगर यहाँ राउज एवेन्यू आना है तो एज ए मीडिएटर मैं रास्ता बता दूंगा, मैं छोड़ने नहीं आऊंगा. आना किसको है? पार्टीज को. तो he facilitates neutral person. What he facilitates? Amicable settlement of the parties, which is developed by the parties themselves. And in this process, he used two techniques, very important: negotiation and communication. Negotiation and communication. Now, what are the various characteristic components they are attached with the mediation process?
Sir, counseling of both of the parties.
Counseling is entirely different. Entirely different. What is counseling? What is psychodynamic counseling? Tell me. You referred psychodynamic counseling. What is psychodynamic counseling?
Counseling is just to read the mind of the parties.
It's a totally different. Forget today. Right. I am asking what are the components. Just try to take out from the definition itself. क्योंकि जो उसकी अच्छाइयाँ वो settlement से अलग थोड़ी होंगी. First, it is the settlement which is developed by the parties. What does it mean? That mediation process recognizes the right of self-determination of the parties. What is right of self-determination? Parties, they are themselves responsible for the settlement. Mediator is only the facilitator. His role is facilitative. He does not suggest any solution. He does not give any solution. Only facilitate. Second, mediation is very, very creative and innovative. What does it mean? कभी आपने जुडिशियल प्रोसेस में इनोवेशन देखा है जज साहब का? अपील में क्या लिखेंगे सबसे पहले? Impugned judgment is based on conjecture and surmises. Why conjecture and surmises? Without application of mind. If you try to find out something new, immediately you will react in a very hostile manner. Sir, ye kya hai? How it is possible? But mediation is very creative, very innovative. Just I will ask I will not take you in that much detail. Mediation is a journey from logical thinking to blend of logical and lateral thinking. Some element of lateral thinking also. Let me check your logical. An apple, you must heard this. An apple is to be divided between two persons. How will you divide? Half, very good. All are perfect neutral persons. But simultaneously you butcher the justice also. It's a typical answer, half. You are mediator, you need to move further. This question I asked in one program at Raipur in Chhattisgarh. If an orange is to be divided between two sisters, everybody shouted on me, sir, half. Because this is basic problem with you. Your mind accept and think certain accepted norms. What is accepted norm? As a neutral person, you need to divide an apple or anything equally between two claimant like suit for partition. Suit for partition. ये आपके माइंड में अभी तक प्रिंट है, पर इससे थोड़ा जल्दी के आगे जाना, इनोवेटिव होना है.
Sir, we can cut the apple into 8 slices and give 2 from this side and 2 from this side.
The properties will change on this side.
नहीं, देखिए, अब मैं आपसे we are around 40-50 here, 65 here. Now give me how you'd like to divide an orange or apple between two sisters. Give different half से अलग होना चाहिए.
एक को एप्पल दे देंगे, एक को ऑरेंज दे देंगे.
एक को एप्पल दे देंगे,
एक को
ऑरेंज दे देंगे. Just one by one.
Depends upon the.
Yes, madam. First, just one by one. One by one. Yes.
So if the sister wants it for her facial, she can get the peel of the orange.
Peel and pulp, right?
And pulp
Very
can be
excellent.
to brother.
सर, आप लोग तो लेक्चर की शुरुआत में मीडिएटर बन गए. गुप्ता जी यहाँ 75 एडवोकेट की ट्रेनिंग करा रहे हैं यहाँ पर मीडिएटर की, और मुझे लगता नहीं आपको जरूरत है.
We need to check the requirement of the parties.
अरे चेक मत कीजिए, मुझे सोल्यूशन बताइए सर.
Sir, plate में रख देंगे जिसको जरूरत.
By making the juice, you can. Or just open your mind. देखिए, I said, give me the answer. I am not asking logical answer. I am not asking the correct answer. I am not asking any meaningful answer. Even give me a nonsense answer also. Just, I want to open your mind.
We can change the structure of things.
कैसे?
We can sell out the apple and
You can sell out the apple and proceed divided.
Mine also same. What is the market value of the apple?
Market value of the apple. और बताओ सर पीछे the gentleman of the juries, those sitting at the back side, you are not out of my frame, sir. If you are not answering, it doesn't mean you are out of my mind. Out of my.
You can see the repeated. तो चेक सिस्टम कर सकते हैं. एक एप्पल, एक ऑरेंज, जिससे एप्पल जो आया वो.
और सोचिए, just 1 minute. अब देखिए, अब आपने have you realized one thing? आपका दिमाग half से अब और सॉल्यूशन की तरफ भी जा रहा है. आपका जो माइंड है वो एक सॉल्यूशन से निकलकर वो मल्टीपल सॉल्यूशन की तरफ जा रहा है. तो that's why mediation is very, very creative and innovative. I will give you 1 or 2 examples how this is creative. You know, one complaint under section 138 CR, negotiable instrument act was filed. The factual background of that complaint was that the accused person has taken the loan from the financial company. He started to open a new business, but he committed default. He could not stick to the financial discipline. On the basis of post-dated check, the financial company has initiated criminal proceeding under section 138. Accused was a qualified chartered accountant, but due to bad luck could not succeed in his business. The bank official said, sir, we know he is an honest person, he wants to repay the loan amount, but he is having no source of income at present. Then क्या होगा? Adjudication में आप बैठे हैं, magistrate साहब हैं आप, क्या होगा? Either conviction or but you know what was settled? I said it is very innovative and creative. The bank has agreed to take services of that accused person as a qualified chartered accountant, and out of the salary, some part of the salary was taken towards the repayment of loan amount, and the rest of the amount was given as salary so that he can survive. So whether this kind of solution they are possible in court adjudication, I will give you one more example. When I was in Delhi Judicial Academy, one case was referred to me by Labour Court. What was that? In one of the function organized by the management was a well-reputed school in Delhi, very difficult to get admission. He created some problem. Domestic inquiry was conducted. After domestic inquiry, he was terminated. He raised industrial dispute, and that industrial dispute was referred for adjudication. Had you been the adjudicator, presiding officer of the labor court, what would be your final decision? If the inquiry, domestic inquiry was conducted as per law, then no relief. If there is a violation of principle of natural justice, then reinstatement, payment of compensation. But this is the end of the road? No. Whether this is the complete justice? No. When I interacted with the parties, I came to know that by that time the workman has died, leaving behind his wife, 2 sons and 1 daughter. The daughter was good in study, but mother, due to poor financial condition, was not able to provide good education. Ultimately, what they have agreed, the school, the girl, that was a convent school for girl, they have agreed to provide free education up to the 12th standard to the daughter of the deceased workman, beside payment of compensation. To see the creativity. But I can give you a number of examples. So this mediation process is very creative. It recognizes the right of self-determination, right? It requires the competence of the mediator. It is very confidential also. You cannot compromise. Court place is the open place, unless and until there is camera proceeding. But mediation is totally confidential. Even the court cannot call the mediator to appear as a witness. The referral court cannot ask the mediator what was deliberated during the mediation. If settlement, terms and condition of the settlement. If no settlement, the case is not settled. That's all. Who is at fault? Nothing doing. Right? Very confidential. Now, what is the benefit of mediation? थोड़ा दिमाग लगाइएगा. What is the benefit of? कॉस्ट सेविंग के लिए आप कोर्ट फीस खत्म कर दीजिए.
Satisfaction to parties.
Let the state to bear the litigation expense.
End of the win-win situation for both the sides, both the parties. End of litigation.
Satisfaction of both the parties. No. मैंने कहा थोड़ा सा आगे चलिए. सोचिए. देखिए, मैं let me tell you. What is the type of court litigation, court adjudication? It is adversarial. It is very authoritative way of dispensation of justice. It is coupled with execution, command, direction, sentence, cause. Have you ever heard a judge is saying the plaintiff is requested to lead evidence? Always parties are direction, only direction, right? No scope for the parties. Court adjudication, pleadings, documents, evidence. But what I consider mediation is a democratic way of dispensation of justice. Parties are sitting together. They are participating in the entire negotiation and bargaining. They are developing, they are generating options. They are presenting their case before the mediator. अगर आप किसी मीडिएशन सेंटर में जाएं तो कोर्ट में क्या होता है? पहले जज साहब, फिर वकील साहब, फिर पीछे पार्टी. मीडिएशन में क्या होता है? मीडिएटर, पार्टीज, देन वकील साहब. सिटिंग अरेंजमेंट इज टोटली चेंज. तो व्हाट आई ऑलवेज कंसीडर द बेस्ट way of benefit or advantage of mediation is the personal empowerment of the parties. Parties, why? They are given for the first time a right to participate in the decision making process. What you said, it is the settlement developed by the parties. Conflict belongs to the parties. It means how they want to resolve the conflict, it should also belong to the parties. Adjudication में तो it is the wisdom of the third party. He may be right, he may be wrong. He may understand your case, may not understand your case. आप लिखते हो ना अपील में without application of mind. देखते हो ना? कोई ऐसा वकील नहीं जिसने ये पाप ना किया हो. Without application of mind मैं अपील में देखता हूँ मुझे भी लगता है यार मेरा दिमाग काम हो गया.
Without application, judicial mind.
सर नॉर्मल माइंड नहीं लिखा, जुडिशियल माइंड भी लिखा हो ना तो कुछ तसल्ली सी हो जाए.
और उसके साथ लर्नेड भी लगा देते हैं.
बस यही है ना कि कड़वी दवाई ग्लूकोज में लपेट के दे देते, राइट. तो इससे पर्सनल एम्पावरमेंट ऑफ द लिटिगेंट्स कि दे हैव बीन गिवन ए राइट टू पार्टिसिपेट इन डिसीजन मेकिंग प्रोसेस. दिस इज नॉट ट्रू इन द लोक अदालत, दिस इज नॉट ट्रू इन आर्बिट्रेशन, दिस इज नॉट ट्रू इन court adjudication, even in the conciliation also. So this is one. This is the time saving, cost effective relation, win-win situation. First, how I would like to address my conflict, how I would like to resolve my conflict, the way in which I like to resolve the conflict is my choice. अगर मुझे भूख लगी है, मुझे क्या खाना है, ये तो मेरी चॉइस होनी चाहिए ना, सामने वाले की थोड़ी होनी चाहिए, मेरे कुक की या रेस्टोरेंट मालिक की थोड़ी होनी चाहिए. Right? So this is the way. Now, how the mediation process work? I just mentioned gathering of information. It may be general information, may be confidential information. I just mentioned for two purposes: to understand the factual background of the case, or to understand underlying interest of the parties. अभी बताया था ना, फादर के क्या है और सन के क्या है, right? Then how the options are generated, and one option can be converted into settlement. This entire mediation process may be divided into 4-5 functional stages of the mediation. First is introduction. Introduction is very important. जब मैडम हर्षिता ने और गुप्ता जी ने मेरे बारे में और गुप्ता जी के बारे में बताया, आपको क्या लगा? क्या लगा? जैसे I am asking for a purpose.
What will you the person who will have to help us out?
Competent person, competent background of the person.
A right person is standing before you. So in mediation में how we start? We start with the introduction. Introduction. Because in mediation there is no pleading, no documents, no evidence, no law, no citation, nothing doing, no arguments, no counter claim or statement of claim, nothing doing. Only source of information, what is the source? The information given by the parties. For that, we need to create a very positive atmosphere in the mediation room. Right? That's why we conduct introduction. Introduction में क्या होता है? We introduce ourselves, ask the parties to introduce themselves. We explain the process, we explain the benefits of the mediation, we address the confidentiality, we settle certain ground rules also. Why all this exercise is required? Neutrality. You said that mediator is a neutral person. So neutral, if I say I am a neutral person, nobody would believe in my words. Unless and until my conduct display or exhibit neutrality in my action. Right? So it's a time to establish your neutrality, develop a very positive rapport with the parties, and create a very conducive a platform for further mediation process. Then joint session. You must have heard joint session. Yes. आपका कुछ लोगों का experience भी होगा mediation में. How will you define joint session? When both the parties are interacting with the mediator. Joint session belongs to
both the
parties. It is good for mediator. It is also equally important for parties. Why it is important for mediator? To gather the information, to organize the information, to know the factual background of the case and underlying interest of the parties. And parties, they also get an opportunity to tell their case in their own language. प्लीडिंग्स में तो आप कलरिंग करते हो काफी. मैंने इंजंक्शन सूट पे लिखा होता है जी कल शाम को आया डिस्पोजेस करना चाहते. कभी होता है ऐसे? मैट्रिमोनियल केसेस में पता नहीं आप क्या क्या लिख देते हो. शाम को मारा, सुबह मारा, दिन में मारा, उसने खाना नहीं दिया, उसने पैसा नहीं दिया, पता नहीं क्या क्या लिख देते हो. सब कलरिंग. बट इन मीडिएशन यू गेट एन अपॉर्चुनिटी, पार्टीज गेट एन अपॉर्चुनिटी अपना केस अपनी लैंग्वेज में बताना और दूसरी पार्टी का केस भी उन्हीं की लैंग्वेज में समझना. ज्वाइंट सेशन बिलोंग्स टू पार्टीज। कैसे, मैं एक एग्जांपल ऐसे देते हैं सभी ट्रेनर वगैरह। एक मैडम हैज गॉन टू एडवोकेट practicing on the family court. She wanted a divorce from her husband on the ground of quarrelity. She narrated the facts. The advocate prepared the pleadings and he handed over to that lady. Kindly go through the pleading. After reading that petition, the wife started to cry loudly and started to weep. It's a natural question. Why, madam, you are weeping so loudly? तो what that lady has said कि वकील साहब मैं दुखी थी, मुझे इतना तो पता था, मगर मैं इतनी ज्यादा दुखी हुई है मुझे आज पता चला। तो वो जो इतनी ज्यादा दुखी है ना, वो हम मीडिएशन में ज्वाइंट सेशन में हटाते हैं, उसको दूर करते हैं, राइट। एक्चुअल व्हाट इज द एक्चुअल डिस्प्यूट दैट इज नॉट may not be presented in the court also. Parties, they are seeking for divorce, looking for, but suit petition for restitution of conjugal right is filed. Many time it happens. भाई petition file किया, मैडम आपकी वाइफ खड़ी है, ले जाओ, नहीं सर, क्यों, I want divorce, पर petition for restitution is filed. तो this actual, फिर we move toward single session. In single session, we try to find out the options and counter option. The exchange करते हैं, offer and counter offer. Then area of flexibility. अब देखिए क्या होता है, how the single session work. Suppose a suit for recovery of rupees 10,000 is assigned to you, right? Joint session में क्या हुआ, plaintiff ने कहा कि sir I want 10,000 plus interest plus my cost of litigation. What the defendant had said, sir, nothing doing, I need not to pay anything, nothing is due against me. Difference क्या हुआ, suppose principal amount, interest and cost of litigation around 14,000. तो पहला क्या distance था, 14,000 and 0. Difference is 14,000. पर इस पे तो settlement नहीं होगा, then we call the parties in single session. In the single session, suppose plaintiff has agreed कि sir, I can forget my litigation expense, I can forgo my interest also. The defendant said, sir, I want to buy peace of mind, I am very fed up of this court litigation, I can pay rupees 2,000. Okay, it's all right. So earlier the difference was 14,000. अब क्या कितना रह गया, 10,000 and 2,000, 8,000. How you bridge the gap? How you bridge the gap? So this is your negotiation by communication. When we talk about mediation technique, so this single session, then thereafter settlement, recording of settlement. It's very, very important. Abhi just सामने भी I was reading in the newspaper, the High Court has directed to the mediator how the settlement is to be recorded.
Justice Swankanta Sharma in Chhattar on 16th of May.
Right.
Guidelines
तो जब इसे process है ना, when we are, तो how we, what is, we use communication and negotiation. Just मोटा I will tell you मोटा सा. Let me start with the communication.
कुछ लोग select होंगे उसमें, आपके जो
मीडिएशन ट्रेनिंग में कौन कौन सेलेक्ट हुआ है? वेरी गुड. Only 3? Only 3? Why low participation from legal aid?
This was not informed. We were not informed of this.
Start opening the websites now.
How the information is vital in our life. Now, what is communication? What is communication?
Then we express our ideas to others.
Suppose in a closed room, I express my anger. Whether this is communication or not?
No.
It is transmission. Maybe your information, transmission is must. Transmission of your anger, feeling, your emotion, whatever you want to transmit from one person to another. Let me finish with 10-15 minutes. What is in my hand?
Glass of water.
Simple question, simple answer. But when I put a question to you, what is in my hand, you immediately responded, it's a glass of क्वार्टर। क्या आप बता सकते हैं कि इस दौरान में आपने बहुत कुछ कर दिया? You have committed many cognizable and non-cognizable offences, for which all of you are liable to be prosecuted without any mercy. एक केस में one counsel said, I am not feeling well, grant me the adjournment. I said adjournment is granted because you are feeling not well, because you are not taking proper rest, you are so committed to your work. It is granted only with the condition that you will go to the canteen, you will enjoy a cup of tea and coffee with biscuit, and you will also invite your friend so that you can enjoy some time in the company of good person. If you wish, you may also invite me also. I can come after adjourning my court work or taking a break. You know how humor is important in the life. You know, humor is very important. I was dealing with one petition under 482 CRPC. It was a question of matrimonial dispute 406-493. Everything was settled. Wife demanded rupees 50,000 more. That husband blasted like anything in the court. So what is going on? And guided by his advocate also, sir, how we can pay poor person, how we manage. I said, it's only 50,000, you are paying multi-lakhs to your wife. I said, 50,000, no, nothing. Listen from my experience. For past 20 years, 25 years, every month I am paying around 2 lakhs to my wife. But still not able to get rid of my wife. And you are getting only just for 50,000. How lucky you are. The counsel said, sir, my client will pay 50,000. It's all right. The choice is yours. I'm paying 2 lakhs per month for the last more than 25 years without any impunity. So that's, in mediation, humor is also important. So this is communication. I'm not going into the details. What had happened, first I formulate a message in my mind, I want to show this. I send the message, it's a medium, I was the sender. You receive this message, this is a water glass, and decode this. What I have sent to you, you exactly similar and same fashion, you decode my message. राइट अगर आप किसी को बर्थडे मैसेज करते हैं तो उसको समझ में आना चाहिए कि बर्थडे मैसेज है और कुछ नहीं है राइट तो दिस कम्युनिकेशन में भी मल्टीपल but modes of communication are verbal and non-verbal. Verbal communication through spoken words, non-verbal communication is very important. The human communication also took place without even uttering a single word. Your body language is very important. You know, our 55% communication is non-verbal communication. Vocal communication is only 7% and 35%, around 30 or 38% is your paralinguistic, आप कैसे बात करते हैं. In mediation, we use many communication skills. First is listening, active listening, affective listening. How will you differentiate between affective listening or hearing? Are you hearing me or listening me? So how will you differentiate me? Who is hearing me? Just raise the hand. That man, madam is hearing me. And who are listening me? You are also listening me. Two things cannot happen simultaneously. There is a difference. Hearing is एक कान से सुना, दूसरे से निकाल दिया. But when I understand the meaning and emotions of the words, it is active listening. कई बार कहते हैं ना, यार तू कुछ मत कर मेरी बात सुन के समझ तो ले. This is active listening. Second technique is the body language. To maintain your body language and try to understand the body language of the parties. I will give you one example in one matrimonial case. Husband was sitting, his father was sitting, and wife was sitting. Wife did not say even a single word against father-in-law. But as and when she disclosed any information to the mediator, he was looking at her father-in-law. If you are a good mediator, immediately you can gather, although the wife did not say anything about her father-in-law, but must be having something in his mind against her father-in-law. अगर आपने इस क्लू को कर लिया तो आपका मीडिएशन का प्रोसीडिंग डायरेक्शन बदल जाएगा. So non-verbal communication is your body language is very, very important. Even eye contact is very important. Have you noticed? I'm moving like this. Why? To have eye contact with all the participants. So that I mentioned you are not out of my frame. Because I am having eye contact with them also. I am not concentrated only the few participants. Each and everybody sitting in this room is under my radar, is on my radar. Another is very important techniques communication is empathy. How will you differentiate between sympathy and empathy? किसी कोई कहता है ना मुझे बस तू मेरी बात समझ ले, मुझे सहानुभूति नहीं चाहिए.
When you step in the and sympathy is just
Honestly बताइए, कभी किसी ने आपने डिक्शनरी में देखा है कि what is sympathy और what is empathy? Have you tried to find out the difference? सब टुल्ले मार रहे हैं. अरे resource person is not without knowledge. ये होता है जी, वो होता है. Honestly बताइए, कभी आपने have you tried to find out the difference between sympathy and empathy? Just I will give one example. Suppose a dispute with गुप्ता जी. मेरा गुप्ता जी के साथ बहुत डिस्प्यूट है कि आप खाने पे नहीं बुलाते हो मुझे, किसी रेस्टोरेंट में नहीं लेके जाते हो. और गुप्ता जी नेवर एक्सेप्टेड टू माय रिक्वेस्ट. लंगर में खाना खिला देते हैं, भंडारे में खिला देते हैं. सपोज मी एंड गुप्ता जी आर हैविंग प्रॉपर्टी डिस्प्यूट. वी आर ब्रदर्स एंड मुकेश गुप्ता जी द मीडिएटर. आई सेड बीइंग elder brother, Mr. Mediator, look at what my younger brother has done. I have brought him up. I spent so much money on him. मैंने उसको सब कुछ दिया, बिजनेस किया. देखिए उसने मेरे साथ कितना किया. He has filed number of cases against me. He has taken up my property. He has eaten up my entire property. What he is doing? So Gupta ji immediately responded, "Oh, your brother is really a cheater. He did a lot of wrong things with you. I'm very sorry to know about your misery." And दूसरे गुप्ता जी दूसरे रूप में कहते हैं, "Oh, Mr. Jain, I understand that you are not happy with the past conduct of your younger brother." So which is sympathy, which is empathy? बड़ा आसान है तो बताना. डिफरेंस बताओ क्या? Sympathy, it means you lost your neutral character. In empathy, without losing your neutral character, what you conveyed, I understand you, but without agreement or disagreement. That's why take care of your judgmental acknowledgement. Never use word yes, yes, oh, nodding your head up and down. Yes, yes, these are very bad acknowledgements. I always say, I understand your point. I understand your arguments. What you want to say, I could understand. But don't say yes, yes, ouch, ouch, not nodding your head up and down. This is very bad exercise. Right? So this is, third technique is empathy. And fourth is asking the right question. अब देखिए क्वेश्चंस कैसे पूछे जाते हैं. आपकी शादी, आपके कितने बच्चे हैं जी मैट्रिमोनियल में? अजी 2 बच्चे हैं. आपकी शादी हो गई? पता चला मीडिएटर साहब की तो एमएलसी विद ग्रीवियस और डेंजरस इंजरी. बट इफ आस्क आपकी शादी हो गई, आपके कितने बच्चे? एट द एंड आंसर इज द सेम, बट हाउ यू आर आस्किंग द क्वेश्चन, इट इज वेरी इंपॉर्टेंट. कैन आई प्रे व्हाइल स्मोकिंग? कैन आई स्मोक व्हाइल प्रेइंग? कैन आई स्मोक व्हाइल प्रेइंग? नो. बट अगर आप इसको उल्टे ढंग से पूछेंगे, ऐसे पूछेंगे, क्या मैं प्रे करते हुए स्मोकिंग कर सकता हूं? आंसर वुड बी नो. इफ आई आस्क कैन आई स्मोक व्हाइल प्रेइंग? आंसर वुड बी यस. तो योर डिजायर रिजल्ट डिपेंड्स अपॉन द वे यू आर आस्किंग द क्वेश्चन. योर एबिलिटी टू आस्क द राइट क्वेश्चन इज ए वेरी गुड कम्युनिकेशन स्किल्स. अदर थिंग्स, अब जैसे there may be a number of types of question, open-ended, close-ended, hypotheticals, multiple question, leading question. Time is not permitting me to go into the details, right? So as a mediator, you need to improve your communication skills in your personal life also. Few days back, I was addressing I managed what I could achieve in my life. It is because of my communication skills also. आपको कैसी लगी मेरी communication skills? थोड़ी तारीफ करो.
Very nice.
Lordship was in charge in T. Suzari, mediation in charge. One of my matter got settled there, Lordship. Then I came to know.
Improve your, like neutral reframing, like your power of summarizing, right? Acknowledgement, that's it. And next technique is your negotiation and bargaining. What is bargaining? Buy one, get one. लिखा होता है buy one, get one. It's a kind of bargaining. You bargain every day. Bargaining is a part of our life. हम भी नेशनल जुडिशियल अकेडमी जाते हैं, वहाँ एम्पोरियम में जाते हैं मध्य प्रदेश गवर्नमेंट के, हम भी उनसे बार्गेन करते हैं, वी आर ऑल जुडिशियल ऑफिसर, जजेस 5% या 10% कुछ तो फालतू दे दो डिस्काउंट. दे एग्रीड. बार्गेनिंग, वी डू बार्गेन. चलिए मैं जस्ट आई विल नॉट बी, गुप्ता जी इज लुकिंग एट मी कि आई एम मीटिंग हिज टाइम. मुझे कुछ दिनों बाद गुप्ता जी हाईकोर्ट में होंगे तो मुझे परेशान करेंगे, कहेंगे वो ये जो आपने मेरा टाइम खा लिया था. चलिए छोटा सा एग्जाम्पल. आई थिंक मैडम्स वुड बी राइट पर्सन टू आंसर देम. एवरी डे यू परचेज वेजिटेबल. ए वेजिटेबल वेंडर्स केम एट योर डोर, कम एट योर प्लेस. यू वांट टू परचेज पोटैटो. व्हाट यू आस्क, कितने का है भैया? उसने कहा जी 20 रुपए किलो. नो नो भैया, आप ना बहुत महंगा है, मैं तो 10 रुपए से ज्यादा नहीं दूंगी. उसने कहा चलो मैडम आपके लिए है 18 रुपया. आपने कहा नहीं नहीं 14, तो 15-16 में बात बन गई. फिर वेजिटेबल वेंडर्स के दिमाग में क्या आ रहा है, यार शी इज माई रेगुलर कस्टमर, आई एम सेलिंग पेरिशेबल आइटम, आई नीड टू अर्न माई लाइवलीहुड, आई कैन नॉट अफोर्ड टू send back my regular customer. What the madam is thinking, I am getting late for my office, I have to cook food for my family, then I cannot afford to go to the market because for that I need to expend something on my traveling also, on my conveyance also, auto rickshaw वगैरह पर, right? Then vegetable vendor also offered, मैडम जी पैसा तो कम नहीं करूंगा पर मैं 100 ग्राम आपको हरी मिर्च, अदरक या प्याज कुछ फ्री. इट हैपन्स एवरी डे. इट टेक्स हार्डली 1 or 2 minutes, 2-3 minutes. इसमें क्या क्या कर दिया आपने बताइए. सब यू विल टुमारो यू विल बी द मीडिएटर. यू नो व्हाट इज मीडिएशन? इट इज बार्गेनिंग एंड नेगोशिएशन. व्हाट इज बार्गेनिंग? It is what is the conflict between madam and vegetable vendor? Is the price. This is the conflict. It requires to be handled properly. When we handle a conflict, it is bargaining. When we handle, you want to purchase a shirt for ₹75, shopkeeper has quoted 100. तो वो जो आपका बार्गेन जो बातचीत है, that is bargaining. When you addressing a conflict, तो आपने क्या कर दिया इसमें बताइए.
Generated options.
कहाँ ऑप्शन आई?
धनिया और प्याज एक्स्ट्रा.
टाइम बचत. वेरी गुड. बताइए, जस्ट ओपन योर माइंड. आई वांट योर पार्टिसिपेशन. चलो लेट्स टेक वन बाय वन. लेट्स टेक one by one.
So extra benefit होगा.
Benefit होगा.
Save the money also.
Save the money.
Regular customer बनना.
I think one of you may be the next finance minister of this country. अगर कैबिनेट नहीं तो स्टेट मिनिस्टर तो हो ही सकता है. देखिए फर्स्ट, what the shopkeeper, this vegetable vendor quoted ₹20. Madam has said 10. Position. Initially it was positional bargaining. Like, if there is a breach of contract, I am entitled for damages. In a suit for partition, I am entitled for my share. This is positional bargaining. So every bargaining starts with positional bargaining. Right? Then 18 rupees, 12 rupees, 14 rupees. It is haggling over price. In this process में, what is the effort? What are the efforts of the vegetable vendors and madam? They are trying to get maximum. A vegetable vendor is trying to sell potatoes at best possible price, maximum price, and endeavor of madam is to purchase potato at minimum price. So when there is a haggling over the price, this is called as distributive bargaining. If we start any bargaining, we start with the positional bargaining, then we proceed with distributive bargaining. But positional bargaining or distributive bargaining पर क्या dispute खत्म हो जाएगा? No. We need to go further. Then we need to convert the bargaining into interest-based bargaining and integrative bargaining. What is interest-based bargaining? The vegetable vendor, what is vegetable vendor thinking? I am selling perishable item. I need to earn my livelihood. I cannot move away my regular customer. तो अगर ये फैक्टर उसके दिमाग में है तो वो उस कॉन्फ्लिक्ट को सॉल्व करेगा ही करेगा. मैडम कैन नॉट अफोर्ड टू गो टू मार्केट. शी इज गेटिंग लेट टू गो टू हर ऑफिस. शी नीड टू कुक फूड फॉर हर फैमिली. अगर ये फैक्टर उसके हैं तो पोजिशनल बार्गेनिंग एंड डिस्ट्रीब्यूटिव बार्गेनिंग विल कन्वर्ट इनटू इंटरेस्ट बेस्ड बार्गेनिंग. नाउ दे विल स्टार्ट बार्गेनिंग टू सेटिस्फाई देयर इंटरेस्ट. एंड नाउ what is integration? When we mix something extra. रबड़ से ऐसे करते हैं ना, ये साइज है, अगर आपने ऐसे कर दिया, दिस इज इंटीग्रेशन. What is such? He offered some green chili, dhania, adrak, onions, whatever it may be. So we are adding something. Like एक सूप प्रॉपर्टी है, पार्टीशन करना. In one property, one of the brother is staying. What he offered? He give me this house, I will give you my another house. So you add something which was not the subject matter. So this addition is integration. This is integration. If we want to resolve a conflict, it always start with positional bargaining. It is proceed with distributive bargaining. But if settlement is there, we need to convert these two into either interest-based bargaining or integrative bargaining or both. They are not isolated from each other. So this is your bargaining and negotiation.
Integrative bargaining is need not necessarily by both the parties, can be by one party.
Often can be by the one party. Bargaining, it's like a joint effort. Offer तो दिया ना, I may accept, I may not accept. भाई मैं प्राइस तो कम नहीं कर रहा, मगर मैं आपको 100 ग्राम हरी मिर्च फालतू दे सकता हूँ. तो इससे समथिंग वाज एडेड. तो दिस ऑफर मे बी एक्सेप्टेड. तो मैडम कह सकते हैं ठीक है, प्राइस मत करो पर गिव मी 200 ग्राम्स. तो ऑफर एंड काउंटर ऑफर एंड देन सेटलमेंट. तो एवरी बार्गेनिंग, जब आप बार्गेनिंग, तो व्हेन लिखा होता है बाय वन गेट वन, व्हाट काइंड ऑफ बार्गेनिंग इज दिस? इट इज इंटीग्रेटिव बार्गेनिंग. समथिंग इज एडेड और इंटरेस्ट बेस्ड बार्गेनिंग कि यू आर गेटिंग वन मोर. तो इसे इंटरेस्ट बेस्ड बार्गेनिंग एंड इंटीग्रेटिव बार्गेनिंग. If there is no negotiation, if there is deadlock between the parties, they are not moving further, what you will do?
Fail the mediation. Fail the mediation.
Parties at deadlock, there is bottleneck, stalemate, not ready to move further.
Adjourn the mediation.
We will give the one more opportunity to the party.
Some time, we'll give them some time. Adjourn the mediation.
Adjourn the mediation. So impasse when parties they are not moving further. This is impasse. It's a normal, inevitable. It can never be avoided. मैं तो कहता हूँ एक अच्छा मीडिएटर तभी बनता है जो वो इम्पास को रिजॉल्व करता है. I always love to create impasse between the parties so that I can exhibit my skills. पहले झगड़ा कराओ फिर उनको शांत कराओ. ठीक है, पहले झगड़ा कराओ फिर शांत. तो ऐसा मत कीजिएगा. राइट. In every mediation, there is a deadlock between the parties. How to resolve? Two techniques very important. Assessment techniques and option generating technique. Assessment, आईना दिखाना. When we assess the case on facts and law, parties को बताते हैं कि भाई आपका केस में आप कहाँ खड़े हैं. अब जब मैं MACT के केस करता था मीडिएशन में, if it is a case of simple injury, what I am likely to get is compensation not more than 20-25,000. But party used to demand, sir 5 लाख दे दीजिए, 10 लाख दे दीजिए, मेरा ये नुकसान हो गया वो. Then show the mirror to the party. मिरर क्या है कि देखिए पार्टीज आपने एनकाउंटर किया होगा, हर पार्टी ये कहती है कि सर माय केस इज वेरी स्ट्रॉन्ग, आई एम लाइकली टू विन इन द कोर्ट। ये चीज दिमाग से निकालिए। अब मैं उसको देखिए कैसे एक्सप्लेन करता हूँ। सर जो है इन द मॉर्निंग, ऑलवेज इन द मॉर्निंग यू गेट रेडी एंड लुक एट द मिरर कि हाउ आई एम लुकिंग। कुछ लगता है कि आई एम लुकिंग लाइक रणबीर कपूर, अक्षय कुमार, वट एवर इट मे बी। कोई ये नहीं कहता कि आज मैं शक्ति कपूर जैसा या कुछ चंद्र ग्रोवर जैसा। क्यों नहीं कहता? क्योंकि एवरीबडी हैज कंसिडर हिमसेल्फ टू बी द बेस्ट। यही चीज उसके दिमाग से निकालेगा। दिस कैन बी डन बाय रियल टेस्टिंग कि यू आर नॉट शक्ति कपूर, you are not Ranbir Kapoor, you are like Shakti Kapoor. You are not likely to get what you are thinking in your mind. So today's settlement is the best possible way to resolve your dispute. ऐसे में मैडम को कहता हूँ कि कभी कोई देखता है शीशे में कि आज मैं ललिता पवार जैसी कोई कह देगा तो उसकी पिटाई हो जाएगी। बट यू नीड टू शो द मिरर टू द पार्टीज, राइट? यू नीड टू शो द मिरर टू द पार्टी, और दिस इज टेस्टिंग टेक्निक। शो द मिरर। वाइफ इज आस्किंग, जी मुझे 50 लाख रहे, हाउ यू आर लाइकली टू गेट 50 lakhs फ्रॉम योर हस्बैंड? टेल मी, कंपेयर, दिस इज द पॉसिबल आउटकम ऑफ द ट्रायल, दिस इज द सेटलमेंट, टूडे सेटलमेंट। तो टूडे सेटलमेंट इज मच बेटर देन टुमारो आउटकम ऑफ द ट्रायल। यू नीड टू मेक कंपेरिजन। तो दिस इज रियल टेस्टिंग और रियलिटी चेक।
जनाब इसमें वो भी पूछ सकते हैं सर तेरे औकात क्या है?
बहुत मारेंगी पार्टी बहुत मारेंगे, बच के रहिएगा। और गुप्ता जी के पास डिस्पेंसरी है पर एम्बुलेंस नहीं है। अब आपकी बात सुन के कहते हैं खड़ी कर। देखिए, आई यूज द वर्ड न्यूट्रल रिफ्रेमिंग। यस, आई मेंशन बट आई डिड नॉट एक्सप्लेन बट द काइंड ऑफ लैंग्वेज यू आर यूजिंग विद द पार्टी इज वेरी वेरी। आई विल गिव यू वन एग्जाम्पल. I took over the charge as judge in charge of Delhi Mediation Center, Rohini Court. One circular was placed before me. What was mentioned in that circular? All the judicial officers are directed to refer cases for mediation. Any default would be viewed seriously. Take notice accordingly. कैसी लैंग्वेज लगी आपको? Very offending, authoritative. I think you may not refer the case for mediation. या नहीं करते जो तुझे करना है कर, नहीं करते क्या कर लेगा? डिसमिस थोड़ी करा दो, सस्पेंड थोड़ी करा दो. I changed. I mentioned Delhi Mediation Center, Rohini Court expressed its gratitude to all the judicial officers for referring the cases. In this period, this number of cases were referred for mediation, out of which this number of cases has been referred. All the judicial officers are humbly requested to refer more suitable cases for mediation. I shall be highly obliged for your kind cooperation in this regard. Matter, message was the same, but see the effect of language. Many officers in lunchroom, Mukesh was also there, they complimented me कि sir, we started to refer the case only after reading the language of this your circular. तो language matter कि how अगर कैसे, अगर आप कोई कहे you are not a good trainer, Mr. Sudhir Jain, you are very bad speaker, I may feel offended. If you said, Mr. Jain, you need to improve the way of your delivery of the content, so I will try to improve myself. The message is the same. So this is neutral reframing, very important technique. So सर ये मत कहिएगा कि आप क्यों काट लिया. Yes, I said assessment strategy. Second is option generating strategy. This assessment is based on your logical thinking. Option generation is based on your lateral thinking. Just last 5 minutes. What is logical thinking? You must have heard what logical. Your Indian Evidence Act is the classic example of logical thinking. If relevant, only then admissible. You ask how this is admissible. It cannot be read into evidence. How this is relevant? When the word relevancy is used, it means it is logical. It is logical. What is logical thinking? When facts are coupled with reasonings to arrive at a sensible decision. Judgment. Facts, decision on the basis of reasoning. When the facts and evidence, they are coupled with reasonings, only then judgment is delivered. नहीं तो अगर उसमें रीजंस नहीं होंगे, प्रॉपर कनेक्शन नहीं होगा, तो आप क्या कहेंगे अपीलेट कोर्ट में? सर जजमेंट पढ़ के देख लीजिए, नो नीड टू आर्ग्यू फॉर दैट दिस ऑफिसर बी सेंट टू अ जुडिशियल अकेडमी फॉर ट्रेनिंग. But lateral thinking is moving away. Logical thinking is 2 plus 2 is equal to 4. But lateral thinking is 2 plus 2 may be 5 also. This extra number is your X factor. Your ability to think beyond box. अभी आपने बहुत अच्छा दिखाया था. When I asked how an orange is to be divided between two sisters, you gave many answers. When I asked how the dispute between father and sons can be resolved, you gave many answers. So it was a reflection of your lateral thinking. अब देखिए, आपने घर में किसी को इनवाइट किया है, यू वांट टू सर्व पुलाव या जो भी है, ये थोड़ी कि गैस पे से उठाया, स्टोव से वो पतीला उठा के उसके सामने डाल दिया, ऐसा नहीं करते ना. खाना बनाना इज योर लॉजिकल थिंकिंग, पर उसको गार्निशिंग करना, द वे ऑफ प्रेजेंटेशन, द वे ऑफ सर्विंग इज योर lateral. So your journey as a mediator is a simple. Your journey is from confrontation to collaboration, from logical thinking to the lateral thinking, from past to future also. It's a court adjudication to dispute adjudication to dispute resolution. So how your journey as a mediator start? So this is now coming to last, your role as a legal aid counsel. I said all of you are the pioneer for the access of justice to the poor. Few days I also mentioned that mediation should not be developed a technique to resolve dispute of the elite group class of litigants. In one training conference, commercial mediation, international mediation, high value mediation, I said Section 89 was not introduced for this purpose. It was incorporated to provide the access to the justice to the needy and poor person. अब देखिए कैसे आप करते हैं. The daughter of my maid was having dispute, matrimonial dispute with her husband. Poor person, they cannot afford. I said, go to the legal aid office, central office, go to the office, hire some advocate. Advocate was provided. Domestic violence and 125 petitions were filed. But with the indulgence of the advocate provided by the legal aid authority, matter was resolved and now she is living with her husband. So this kind of role, very positive, constructive, innovative role you need to play in the resolution of dispute. Take a district court, they are the media for mass justice. District court, they are really meant for the persons, those who really need justice. They cannot purchase the luxury justice. In High Court, you will find in arbitration, appeal, either under section 34, 37, battery of senior advocates, they are standing before you arguing. No, this is not the mandate of section 89. The mandate of the section 89 is to provide the real justice. In the beginning, I used the word sustainable justice, not the fluid justice. Who will provide the sustainable justice? All of you. Don't undermine your role as a mediator, role as a lawyer, legal aid lawyer. और देखिए, मैंने जब गुप्ता जी पे यहाँ पे सिलेक्शन भी हुआ, जब मैंने भी सिलेक्शन किया, I selected only those advocates as mediator, those who have shown their inclination how to serve the society, not to earn the money. जिसने ये भी कह दिया ना कि अगर पैसा मिल जाए तो ठीक है, कोई बात नहीं. That was the beginning of the mediation. We want to establish the mediation in this country. I said no, goodbye to you. No, I know money is very important. I have to run my kitchen also. I need to earn my livelihood also. But first principle of all the legal aid panel lawyers must be the service to the society, service to the poor person. Right? So all of you need to understand what is the nuances of mediation, what are the benefit of the mediation, how the mediation can be used in the resolution of dispute, particularly of the poor person, needy person, those who are living belong to the lower strata of the society. You are the champion of cause of justice for actual needy person. not for the elite group of litigant. आपको कोई बड़ी बड़ी मल्टीनेशनल कंपनी एंगेज नहीं करेंगे. आपके पास कौन आएंगे? जो गरीब है, जो पुअर है, इग्नोरेंट है, इलिटरेट है, जिनकी जिंदगी सुबह एक वक्त के खाने से शुरू होती है और रात के खाने पर खत्म हो जाती है. उनको ये चिंता होती है कि अगले दिन खाना कैसे मिलेगा. उन लोगों का काम आपने देखना है. तो ट्राई टू अंडरस्टैंड योर इंपॉर्टेंस इन एंटायर मीडिएशन मूवमेंट. सर्व द कंट्री. ठीक है, I need money for my survival. But simultaneously, once I have taken this job as a panel lawyer of the Legal Aid Services Authority, so I need to understand my duties also. My duties are totally different, totally peculiar. My duty is to deliver or provide or to impart justice to the needy person. So I know all of you are well experienced advocates. All of you are doing very good cases, presenting good cases. और मेरा तो काफी अच्छा सेशन में बड़ा और एमएम कोर्ट में बड़ा अच्छा एक्सपीरियंस रहा है लीगल एड एडवोकेट के साथ. दे आर सो कमिटेड, सो डेडिकेटेड. इनके भी साथ मेरा एनकाउंटर हुआ, कोई ऐसा नहीं मुझे लगा. और आप सभी बहुत मेहनत करते हैं. ऑल ऑफ यू आर क्वालिफाइड, इंटेलिजेंट एडवोकेट. यू आर हैविंग योर ओन प्रैक्टिस. इवन देन, डिस्पाइट योर बिजी प्रोफेशनल शेड्यूल, you choose to serve to the society. So I must salute to all of you for your commitment, for your dedication. So this is something very little about the mediation. So thanks to all of you. गुप्ता जी is the champion of mediation. He will, जहाँ मैंने गलती की वो गुप्ता जी इसका सुधार कार्य करेंगे. Thereafter, if you are having any problem, you are eligible.
After giving this thoughtful dialogue given by Dr. Jain, I think nothing is left. And one thing I just wanted to add, as Mukesh ji in the beginning has said that he has taught him organic chemistry in 11th class. Similarly, he has been my guru also. He has taught me this mediation training. From him I have got the mediation training. So, whatever has been stated, you take it as a Bible for mediation. The theoretical aspects blended with the practical examples. I think you must have got it very well in very clear terms how you as a legal aid lawyers have to indulge yourself in mediation process. I have nothing more to say. Thank you so much.
Any answer?
I'm stuck with that last example. How
cognizable offense ki you should be very careful about your selection of messages. And non-cognizable is when we need a media to send our message, right?
Thank you.
Sir, I must say this is one of the most wonderful sessions I have ever attended, and I'm sure I'm echoing the sentiment of the entire group. Just thinking about it as to what the legal aid counsels should keep in mind specifically while preparing their litigants before the cases are referred to mediation. Is there something special that they need to keep in mind, sir?
When a client is encountered with you, you are the first person in whose contact a litigant may come. At that time, your role as an advocate is important before mediation, during mediation, and after mediation. You need to prepare the client or litigant to go for mediation by highlighting mediation process, by highlighting the benefits of the mediation, what is the role of mediation, the confidentiality, flexibility, innovativeness about the mediation process. And simultaneously, you need to convey, if mediation fails, then further litigation is no bar. You can go back to the court. And mediation will satisfy your underlying interest. It will result into win-win situation. Mentally prepared. If you prepare the litigant in your contact before entering into the mediation room, he will enter into the mediation with more positive. And then during the mediation, try to help your client to generate more and more options. Try to make him understand, to give more and more relevant information. Don't be inflexible. Address your emotion, anger, your sentiments, your feelings, what you expect from the opposite party, right? And make him understand that this settlement is in your interest. Sometimes the parties, they accept the mediation settlement as a symbolic of their lose. If they have lost the legal battle, their case is very poor. So you need to convey to the parties, it's a win-win situation for all, including you also. What you could manage to get today by way of mediation, you are not likely to get out of court litigation. And then post-litigation, how to execute the terms and conditions of the settlement honestly. Honestly. If there is no settlement, prepare for next round of mediation. I still remember in Rohini court I settled one matrimonial dispute in my 6th attempt. In my 6th attempt. So don't lose battle. It may be temporary loss, but never believe in this case can never be settled. You have to make the parties very positive. You need, what depends? Everything it depends upon your attitude. If positive or negative. How you see the world. How you look at the world. It's very important. How you accept the world. It's very important. So it depends upon your attitude. So you need to develop a very positive attitude in the clients. So you are the right person to do all these things. Right? If a dispute can be settled, it's all right. If a dispute cannot be settled, it's all right. Because it is the settlement for the parties. मीडिएटर की कोई हार नहीं होती है. मीडिएटर तो एक फैसिलिटेटर है. डेडलॉक है, it is only for the parties, not for the mediator. And don't feel any performance pressure. कैसे? एक बार एक पोल्ट्री फार्म में के ऑनर ने सब मुर्गियों को कहा कि कल से 2-2 अंडे देने हैं, नहीं तो तुम्हारा सारा खाना पानी बंद. सब मुर्गियों ने 2-2 अंडे दे दिए, बट एक बेचारी मुर्गी ने एक ही अंडा दिया. तो वो पोल्ट्री फार्म का ऑनर बड़ा गुस्से हुआ. अरे तुमने एक ही अंडा दिया. तो व्हाट द मुर्गी सेड कि ये भी मैंने परफॉर्मेंस के लिए दिया, वरना मैं तो मुर्गा हूं. तो डोंट रील अंडर परफॉर्म. ट्राई योर बेस्ट. Try to give best to the society. So I even in my entire career, I never feel any performance pressure. अच्छा हो गया, बुरा हो गया. अच्छा हो गया सामने वाले के लिए हो गया, बुरा हो गया सामने वाले के लिए. I have nothing to lose in my pocket. चाहे एज ए ट्रेनर, एज ए मीडिएटर, अगर मैं फेल हो, अगर मेरी सेटलमेंट नहीं हुआ तो पार्टीज का सेटलमेंट नहीं हुआ. एज ए ट्रेनर अगर कुछ गलत हो गया तो पार्टिसिपेंट को समझ में नहीं आया, उसमें मेरा तो कुछ नहीं है. राइट? तो इस टू कीप अपराइट योर पॉजिटिव एटीट्यूड इज वेरी इंपॉर्टेंट. I have seen many advocates in the court. Yesterday I was telling to one lady advocate, she working with standing counsel, central government standing counsel. It was a issue pertaining to the grant of sanction in CBI prosecution. So it was the argument on territorial jurisdiction. Last date of hearing, I said, Mr. Singh, I will not hear argument from you. If you argue, adverse order is passed against you. Take it down. How the young advocate would grow? Ask your young lady advocate to argue before you. So she argued. Then at the end, madam, few points for you. During argument, you lost eye contact with me. You were looking constantly at your laptop or padlet, whatever she was carrying. So what you want to convey, it was not reaching to me. You were reeling under the performance pressure. How to perform? My senior ने तो बाहर जाइए आप, Mr. Singh, out from my photo. Nothing to do. आपके लिए कुछ नहीं है. But many other advocates there, but she was feeling, but she was first timer, I think. And second, मैंने कहा very important, how to start your argument, how to proceed with your argument, and how to conclude your argument. We start argument, we proceed with the argument,
but we always forget how to conclude our arguments. And then your vocal variety also. एक समान गति है ना, वो न्यूट्रन का एक समान गति से चलता रहता है, उस गति से अगर आप आर्ग्यूमेंट करेंगे कोई नहीं समझा, मैं तो बिल्कुल नहीं समझा, नींद आ जाती है. I said one senior advocate कि महंगा Mr. Counsel, by your argument I am feeling sleepy. I'm sorry to say. So how to change the variety, vocal variety, यानी the way of your speaking. Say how you can do. So you need to learn the art of advancing argument, making your presentation, because हम जो argument करते हैं वो presentation form में करते हैं. तो ये है सर. तो don't read under. तो I think सुशांत जी, I am able to answer your question. और बताइए, और किसी के मन में कोई दुविधा हो?
genuine question.
इससे नॉन कॉग्निजेबल क्वेश्चन.
Sir, I personally. Sir, on certain instances, I have realized that being a legal aid counsel. Sir, being a legal aid counsel, at times from the bench, representing against a financial institution a person who is from the deprived class, there is certain preconceived notions against me before I start, that he must have not is taken financial aid, and then and a settlement has already failed at the initial aid, the pre-institution mediation has already failed. Then to insist, I have realized at a few occasions or before different judges that it works, the perception gets stronger when I seek for sending it to mediation, and again it's a very uphill task. Financial institutions are very strict in their positioning that no, will not give you installments and other things. Then it gets very difficult. I've got a few matters settled through mediation, got them referred, but this sentiment, because as to the topic, it was our role to get it referred to mediation. So that sentiment, it gets very risky. So I just wanted some of the thoughts.
We are all victim of our bias and prejudices. We are all victim of our own stereotypes. It may be from the judicial side, maybe from the advocate side, maybe from the litigant. There may be some prejudice, bias against the legal aid panel advocate. He may not be prepared. He is more interested in the fee. He may not be taking the care of his client. The case assigned to him, marked to him. In mediation also, you may be serious, may not be serious. How we can remove this prejudice and bias by our own conduct, our own preparation, and how we present the case. If you are good in your advocacy skill, I think it will vanish away, wither away in one or two cases. You need to show seriousness. Why? Sometimes, what we have encountered on judicial side also, the government panel lawyers, advocates, they all depend upon the inputs from the department. Sometimes they are not getting proper inputs from the department. The officials, they are not coming to them. The relevant documents are not provided to them. Even all is done, sometimes the advocate, they are not prepared. That's why, preparation is the key of your success. It reduces your nerve by 95%. If you are prepared. Sorry, today I was not prepared. I could not find any time to go through the material. So prepare yourself. Prepare, then present. Suppose 10 cases are fixed. You can say 5 cases. Sorry, sir, I could not prepare. I need accommodation. But whatever you prepare, it must be up to the mark. Lage ki you are serious in your business. और देखिए, we are living in the world of marketing. We are living in the world of competition. We are living in the world of performance. So that we need to produce result. We are professionals. We need to display our professional skills and knowledge. Why training? To improve your knowledge, to refine your skills, to change your attitude. I can do everything in my life. I can do. I can try to do. Prepare. If you are, what it is, some advocates, they are having the habit to misguide the court always.
by giving wrong information, by referring wrong documents. Say, be honest with the court. While sitting on the judicial side for about more than 31 years, I can say that honesty is the best policy. Your good reputation is the best gain in your life. Right? Oh, thank you. Thank you very much for your kind. Really, I also enjoy with my interaction with all of you. In the beginning, I said all of us are the resource person in this room. Me and Gupta ji are not the two resource person in this room.
Just one thank you from us, institution.
Thanks a lot, respected sirs, for so beautifully elucidating the spirit underlying mediation and responding to the queries. After hearing you, I am reminded of the words of Bapu, who described his experiences while mediating disputes, even while he was having a thriving legal practice. He says, and I quote, "My joy was boundless. I had learnt the true practice of law. I had learnt to find out the better side of human nature and to enter men's hearts. I realized that the true function of a lawyer was to unite parties riven asunder. The lesson was so indelibly burnt into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises in hundreds of cases. I lost nothing thereby, not even money, and certainly not my soul. I'm sure after today's session, our empaneled lawyers shall look at mediation from a different prism. They shall explore the possibilities of mediating a dispute, thereby acting as a catalyst, providing a healing touch to the litigating public by amicably resolving their disputes. Despite their long training in adversarial litigation, our empaneled lawyers shall try to build a wall or a bridge between parties by exploring mediation techniques. It is hoped that they shall give up their hitherto entrenched apprehensions and reservations qua mediation techniques and shall don the mantles of mediators so as to arrive at an informal, collaborative, future-looking and interest-based conflict resolution. On this note, I would like to call upon Shri Sushant Changotra, Learned Special Secretary DSLSA, to kindly deliver the vote of thanks.
Dr. Sudhir Jain, Sir, Honorable Judge, High Court of Delhi, Shri Vinay Gupta, Sir, Learned Principal District and Sessions Judge, Rao's Evening Court, Shri Mukesh Kumar Gupta, Learned Member Secretary of Delhi State Legal Services Authority, my colleagues, Ms. Harshita, Shri Lalit, and all the dear Legal Aid panel counsels present here and who are watching us live on YouTube as well. A very warm good evening to all of you. It is my proud privilege to extend this vote of thanks on behalf of Delhi State Legal Services Authority to this august gathering. It is a matter of tremendous pride and honor for us that we have Honorable Mr. Justice Dr. Sudhir Jain, Sir, Judge High Court of Delhi, and Shri Vinay Kumar Gupta, Learned Principal District and Session Judge from Special Judge, PCI, CBI, Rao's Avenue Court, amongst us today. It is a mandate of DSLSA to provide free and competent legal aid to the beneficiaries under the law. Competency for professionals means not just acquisition of knowledge, but also regular harnessing of new techniques to improve the skill sets and knowledge base. We at Delhi State Legal Services Authority have always laid greater emphasis on enhancing the competency of our legal aid counsels by organizing refresher training programs, not only on the core areas, but also on the diverse subjects of law. In order to render best professional services, it is our duty not just to consider the point of view of litigants, but to think from their perspective as well. Thinking from the perspective of a litigant, the best solution can come forth when he is completely involved in the resolution of his or her dispute. Therefore, the technical knowledge of means and methods of assisting the litigants to settle their disputes through amicable means becomes imperative for all the lawyers. We are extremely grateful to our most respected speakers for today, Honorable Mr. Justice Sudhir Jain, Sir, Judge High Court of Delhi, for accepting our humble request to enlighten our legal aid counsels on the subject. Personally speaking, sir, right from our early days in service, any one of us could walk down to your chamber for seeking guidance. And with your inimitable style, as you have displayed today, sir, you would suggest precise and pragmatic solutions to all our problems. Sir, I'm sure that even today the wisdom that you have bestowed on our legal aid counsels and other members of audience will go a long way in helping us achieve our objective of free and
competent legal aid. Once again, we thank you, sir, for enriching this gathering with your in-depth knowledge and for highlighting the importance of alternate dispute redressal mechanisms in justice dispensation and their role as legal aid counselors. We are also extremely grateful to Shri Vinay Kumar Gupta, sir, Learned Principal District and Sessions Judge, Rouse Avenue Courts, for sparing his valuable time from his busy schedule and for guiding this august gathering with his insightful knowledge and expertise. Sir, we thank you for gracing this event and we will look forward to your guidance in our future endeavors as well. The work of state legal services authorities is shaped by the member secretary of the authority. It is indeed our good fortune to have Shri Mukesh Kumar Gupta as our learned member secretary, who is embodiment of sharp acumen and leadership qualities. Sir, I express my sincere gratitude for encouraging all of us to do our best. I would also like to thank Ms. Harshita Mishra, Learned Secretary Litigation, for being the charioteer of today's event. My special thanks are reserved for dear colleague Shri Lalit Kumar, Secretary Rouse Avenue Court, who has literally put in his heart and soul for making this event a success. The team of legal literacy, consisting of Ms. Pratishta, Ms. Jayanti and Ms. Priya, deserve a special applause, not just for putting in their best for this program, but for all the legal literacy programs that we organize from time to time. Thank you. I am fortunate enough to be backed by the IT team at DSLSA. My special thanks to the dedicated team of procurement branch of DSLSA, Sudhir, Pankaj, Amit, and everyone in the team has worked beyond the call of their duty to contribute towards the success of this program. I also thank the caretaking branch of Rouse Avenue District Court Complex and Mohit for always extending their full cooperation to us. Last but not the least, I thank all of you, our legal aid counsels who are present here or are watching us live on YouTube. You are the pillars of our strength, and success of our institution is measured by your commitment. I once again thank all of you for attending this seminar today. I thank all the staff members of Delhi State Legal Services Authority for making such wonderful arrangement for today's program. It is said that awareness precedes choice and choice precedes change. I sincerely hope that we all will be able to make a difference. I once again thank one and all who have joined us today for this program. I request and expect continued support of all for furthering the motto of Vishwas Sabke Liye, Nyay Sabke Liye. Thank you very much.
Thank you so much, sir. I request this august gathering to kindly rise for the national anthem.
पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा